Hello, everyone. Let's wait for the rest of the people to join us while we're waiting for our friends and people get notified about this session. Let me introduce myself. My name is Al Parsai. I'm the author of this book, 88 Tips on Immigration to Canada. I have been an immigration consultant since January 2011. So it's been more than 10 years that I'm practicing independently. I also teach immigration courses at Ashton College in Vancouver. My practice is in Toronto, Ontario, and I'm actually live from Toronto, Ontario. And we are going to talk about some of the updates in relationship to immigration to Canada. And then if you have any general questions, I'd be more than happy to answer. I cannot offer immigration consultation over the live sessions, but obviously if you have a generic question, I'd be more than happy to answer. When you post your questions in the chat box, if you see that I'm not answering it yet, don't worry, I will definitely answer every single question. You don't need to repeat them, and just wait. When the time comes, I will answer your questions. So a little bit of updates in terms of TR to PR pathway. So it slowed down from the beginning when we started the program. So as you probably know, it covers three different major groups: essential workers, and also healthcare workers and international students. All of these groups are people who reside in Canada and working in Canada right now. And then also there is a cap for each of these groups. So for healthcare, we have a cap of 20,000 applications. For essential workers, 30,000. For international students, 40,000. However, if you're a francophone, you can apply under each of these groups and there will be no cap on these groups. So that's something that you may consider if you know French language. And when I say French, you don't need to be extremely fluent in French. You just need to have NCLC 5 or higher for international student stream, and NCLC 4 or higher for the other two streams, that is essential workers and healthcare workers. But if you are not a francophone, there is a cap. For francophones, this program will be open until November 5th, 2021. For the non-francophones, it will be also open till that date. However, there is a cap, and if the cap reaches, then you cannot apply. And in fact, the cap reached for the international student stream in about 27 hours from the time that they started the program. So all 40,000 applicants applied. So unfortunately, you cannot apply unless you know French and you are considered a francophone. With the other two groups, essential workers, so as of right now, so this is the most up-to-date report that I can give to you. So for under healthcare program, 1,594 people have applied so far out of 20,000. So as you can see, there's a lot of room. More than 18,000 more people can apply under the healthcare stream. And for the essential workers, about 35% is full. So 10,901 people have already applied out of 30,000. So roughly speaking, about 29,000 more people, 19,000 more people could apply. And as I mentioned, under the Francophone programs, there is no cap. So right now for healthcare under Francophone, only 34 people have applied, but as many people as they want, they can apply until November the 5th. We have 374 applications submitted as essential workers, 4 francophones, and 224 as international students. So as you can see, there's a ton of room for application under this program. And if you want to know about the express entry situation, still the government of Canada does not invite people under federal skilled worker class or federal skilled trades class, mostly because majority of people who apply under these two groups, they are outside Canada, and the government cannot allow people to travel to Canada because of travel restrictions. So unfortunately, they only have limited themselves to those people who are mostly inside Canada, and that's the Canadian experience class, and also PNP applicants, because roughly speaking, about 90% of these people, they are inside Canada. So last week, on May 26th, the government invited 500 people on their PNP programs to apply. The lowest CR score was 713, which is amazing considering that you could receive up to 600 points if you are applying under PNP. So in other words, when we say the lowest score was 713, the actual score of the person could be as low as 113, and it just boosted up because of the selection by the province. Of course, if you want the older statistics, on May 20th, the government invited 1,842 Canadian experience people, and the score for Canadian experience class dropped to 397, which is amazing because it's lower than basically 400. But still, if you are applying under federal skilled worker class, or if you're applying under federal skilled trades class, if you have already entered the pool of express entry, don't get disappointed. Last year we had the same issue, and I think the government restarted inviting people in August of 2020. At that time, the scores were as high as 470 something, 74, 78, and then it gradually dropped to 468 by December. And I think if they're considering that the government intends to receive 435,000 new immigrants in 2022, when they start accepting applications under the express entry system, we will see a drop in the scores very soon. So let's keep our fingers crossed that good things will come. Before I start answering questions, there are a couple of other things that I want to share with you. One of them is about PGP, or Parents and Grandparents Sponsorship. Still, there is no word by the government when they are going to accept applications under this program. But if they do, according to what promised last year, they are going to accept 30,000 applications this year. And that will hopefully allow many people to be selected to sponsor their parents or grandparents. Obviously, if you want to sponsor your parents or grandparents, you need to be either a permanent resident of Canada or a Canadian citizen. You need to live in Canada for at least 3 or 4 years. This is the minimum, because you need to show your income in the past 3 years based on your notice of assessment, and the income needs to be 30% above LICO, LICO. If you are not familiar with the concept of LICO, just look up LICO 2020. My article is usually number 1 on Google, and you can read it and understand what's going on in that area. So that's for parents and grandparents. I received many calls, and especially from my own clients, about their applications to sponsor their spouses or common law partners. So initially in October 2020 until probably early February 2021, the government increased their workforce to process spousal sponsorship applications. We had very good progress at the time, but unfortunately, the third wave of coronavirus hit. And that's why the CPC in Mississauga, or Case Processing Center in Mississauga, Ontario, and the Case Processing Center or Central Intake Office in Sydney, Nova Scotia, they stopped again working in full force. And unfortunately, that slowed down the spousal sponsorship applications. The normal or promised processing time for spousal applications by the government is 12 months. But considering the realities of today, you expect that it could take way above 12 months to receive a response in terms of final response about your application to sponsor your spouse or common law partner. Having said that, there are some measures by the government of Canada that you could request a travel exemption for your spouse or common law partner. If they agree to issue visas and travel exemptions to your spouse or common law partner, they can join you here in Canada, and at least you will be together while waiting for the sponsorship application. And of course, if you have applied under in Canada class, then although you qualify for a work permit, and you can apply for a work permit, and definitely if I have a client, we will apply for a work permit for them, but the processing time for that work permit is also in shambles. It could take several months before they actually process that application. In the past, it usually took anywhere between 2 to 6 months to process most of those work permit applications. But nowadays, it's not clear when they will process the work permit applications for spouses of in Canada class applicants. That's why if you're in Canada, although it is okay if you overstay under the in Canada class spousal sponsorship, but to avoid any confrontation by Canada Border Services Agency or any issues with the immigration authorities, I highly recommend that you extend your stay in Canada while you are waiting for your in Canada class work permit application. So that's the gist of it about the cases that people usually ask questions about them. Now let's go back to questions. So DM say hi there, hi there. After receipt of ITA, if possible to remove education and work experience of a spouse if points not claiming under express entry. Well, this is so basically, generally speaking, this is a weird act by a person. I mean, let's set aside the reason that why you say that somebody is educated, and then after you receive the ITA, you say that this person is not educated. So the first thing that crosses the immigration officer's mind that this is a case of misrepresentation. So initially somebody claimed that I'm an educated person or I have work experience, and now after submitting the application or after receiving an invitation to apply, then suddenly I claim that I don't have that education. So you have to be very careful. Any kind of contradictory information that a person offers to the immigration authorities, that could cause problem. And it doesn't just go beyond that, because nowadays, especially people who receive ITA, they mostly live in Canada. It means that they've already interacted with the immigration authorities. Either you had a work permit or a study permit or visit visa to Canada. So you probably have mentioned those things in your visa application, a work permit application or study permit application. And if suddenly you deny it, then that could raise some eyebrows. They think that why on earth somebody makes that claim. And that could be the basis for misrepresentation and refusal of the application. Now, sometimes we make a claim and the claim is truthful, but the problem is that we cannot produce the documents. Now, there are several reasons that a person cannot produce documents. For example, sometimes because you do not have access to the resources to receive those documents. Imagine somebody is here in Canada and they try to collect their their educational credentials in their home country, but unfortunately, because of coronavirus, the organizations that they deal with them, they are not cooperative, or you have to have a physical presence in your home country to do that, and this is not an option. Those kind of things could happen, or sometimes because the person that you are referring to is not cooperative. For example, you had an employer and you enter a fight with that employer fired you. Now you cannot go back to them and ask for a work reference letter because they will deny issuing the work reference letter. So these adverse situations could happen. But in a truthful situation, your role is to explain those to the immigration authorities rather than hide them from the immigration authorities. How do you explain them? It depends on the situation. Obviously, I cannot come up with a simple answer. So what we do with our clients is that depending on their case, then we try to explain the situation in a proper manner, and of course with evidence to the immigration authorities, and try to convince them. Sometimes you can produce the documents, but not in the time frame the immigration authorities give you. In those situations, there is a chance to buy time. There are tools that we can buy time for our clients, and then they will collect the documents, and eventually they will submit the documents. So one thing that you have to keep in mind is that if for some reason your application gets refused, the worst case scenario is that your application has been refused. And I know that it's heartbreaking for people if they say their immigration application is refused or visa application is refused. But at the end of the day, in most cases, even if you receive a refusal, you can almost immediately reapply for immigration to Canada. Now, sometimes it becomes impossible because that method of immigration is not there or something like that. But generally speaking, if somebody gets refused, there is still hope. But if you receive misrepresentation, then misrepresentation means inadmissibility to Canada for 5 years. It's huge trouble. And even after 5 years, although the misrepresentation has been lifted, still any application you make to the immigration authorities, it's subject to scrutiny, and they may look into your documents, they may question you, they may interview, etc. So whatever a person does, they need to make sure that they do not act in such a way that the officer goes in the direction of misrepresentation. Any efforts in hiding information from immigration authorities, producing fraudulent documents, altering the documents, all of those activities that could affect the decision of an officer, or anything that contradicts your previous applications, that could result in misrepresentation. So be careful with that. Okay, so the next question is by Mr. Future. Thank you so much for your time. And service, Mr. Al, my question is, thank you very much for being here. My PR got approved on HNC based on, and I need an ARC. So how much chances do I have for approved ARC application? Well, nobody can say how much. First of all, I don't know about the specifics of your case. Obviously, I cannot comment on that. But nobody can say what would be the chances of an application for ARC. But what I can say is that some applications are those applications that you need to take them very seriously. So there are some applications like express entry applications, or for example, a simple visa application or a work permit application. People might think that they don't need a representative to help them. Well, not necessarily, because I've seen many cases that they hired us for their express entry application, etc., and they seem to be okay and easy, but they weren't. I have a client that he holds a postdoctorate, and he got refused his express entry application twice, despite that he's a super intelligent person. But simply put, He doesn't know the immigration law, and that's why, because of some minor mistakes, his application was refused twice, and eventually he hired me and my team to help him. Now, if we set aside those kinds of applications, there are certain applications that you have to hire a representative, a highly knowledgeable representative. Authorization to return to Canada, or ARC, is one of them. Pre-removal risk assessment, is another one. Rehabilitation, or deemed rehabilitation applications. TRP applications, temporary resident permit applications, HNC applications. These are complicated kinds of applications, and I think ignoring that you need advice from a person who knows what's going on is it just goes in against you. Keep that in mind, of course. No matter who you hire, that doesn't guarantee the success. By the way, because I talked about immigration to Canada, just a quick tribute to Mr. David Cohen. So you probably know David Cohen, or even if you don't know, you have probably used his services through CanadaVisa.com. And he was an immigration lawyer that unfortunately he passed on May 14th, 2021, after several years of his battle with cancer. So it's sad to see a good practitioner passing. So I just wanted to mention his name here. Okay. So the next one. So Paratik Kumar says, "Hi Al, I had joined last week. Also have dropped in a request for assessment or consultation. Look forward to speaking to you soon." Thank you very much, Pratik. Yeah. So in terms of consultation sessions, I don't know what steps you've taken, but consultation sessions are not free. So if you have already paid for consultation sessions, I almost immediately get in touch with you and we will arrange a meeting. If you haven't, then that's not an option. However, if you have filled out our assessment form, our team will review the assessment forms. If they find an opportunity for you, they will get in touch with you for sure. If they do not get in touch with you after a week, it means that they couldn't find an option. So the next one is the points were not claiming from spouse and difficult to get documents. That's the reason. Again, I cannot offer immigration advice here because I don't know the specifics of your case. But generally speaking, this is a very bad move. Let's put it this way. If somebody claims that they studied in and then they say, no, I didn't study, that's a very bad move, extremely bad move. I cannot come up with any excuses that justifies why I claim that I studied, I have educational credentials, and then suddenly I say, no, I don't have educational credentials, So that's the generic, the best answer that I can give you. But if you really want my official advice, you can book an appointment. We can go through your case, see what's going on. So Smartboard says, "Hello, sir. Harmish here. I have worked 22 hours per week for a few times. Can I apply under the PR or TRPR, or I should avoid it?" So Smarty Boy or Harmish, thank you very much for getting in touch with me. Well, again, I cannot offer immigration advice here in a public forum. But from what I'm understanding is that you're claiming that you have an infraction of the Immigration Act. In other words, you were supposed to work a maximum of 20 hours per week, and now you have worked 22 hours per week. So that's a huge problem because you could receive an exclusion order by under Section 41A of the Act. Again, I cannot go beyond this. I really need to see your documents and talk to you in person to offer advice, but that's a dangerous step to take. Hey, Andy, good to see you here. Hi, Al, and my greetings from Dominican Republic. Oh my God, good for you. That's amazing. Yeah, that's so sad. I mean, losing David Cohen is so sad because I don't think anybody who has worked with immigration try to learn something about immigration, whether you're a practitioner or you are an immigrant or you just Googled information, you have not seen CanadaVisa.com. And this is what David Cohen created. And unfortunately, he passed a couple of weeks ago. So it was really sad to hear that. So, Lucila Castillo, as visitor status, can I apply for an electronic student visa selecting I am outside the country and if it is approved, can I get the port of entry to re-enter if it is? Honestly, I don't know what do you mean by electronic student visa selecting. So I wish I knew what your question is. But if you are outside Canada and if you apply online for study permit and then they approve your study permit, what will happen is that they will issue a letter to you, and that letter says that you are you can enter Canada to collect your study permit. So in normal days, you just take that letter. Now, if if you're from one of those countries that they need a visa, they attach a sticker in your passport, a counterfoil in your passport. If you already have a visit visa, it's up to the officer. In 95% of the cases, they will attach a new sticker in your passport because the GCMS code will change from V-1 to S-1. But in probably 5% of the cases, they don't actually attach a new visa to your passport, but you need that letter, the letter that says your study permit is approved, regardless of whether they attach a new visa sticker in your passport or not. Then you will travel to Canada, and then at the port of entry, you present that letter that says your study permit is approved. The officer at the port of entry will scan the letter, and they will print the actual study permit for you, and they hand it over to you. Now, having said that, a couple of things. Obviously, the officer may question your entry to Canada under Section 180 of the regulations. So they have the authority to, even for somebody with this setting, do not allow them to enter Canada, albeit these kinds of incidents are extremely rare. The other issue that you need to know is that because of coronavirus, many of international students right now, they are not allowed to travel to Canada. They need to remain in their home country until this fiasco of travel restrictions are over. There are some exceptions to that rule. If your school is identified as a school that has a COVID readiness plan, then they may allow you to travel to Canada. This, of course, situation could change rapidly because of the because of the situation that we are dealing with the vaccines. People are getting vaccinated, so hopefully they will, by the end of summer, they will remove at least most of travel restrictions, if not all of the travel restrictions. So that's what we are predicting. Okay, so she says I'm inside Canada. Okay. So first of all, again, I must emphasize I'm not offering you immigration advice because I don't know your situation. But generally speaking, a person who is on a visitor visa inside Canada, they are not allowed to apply for a study permit. And in other words, after entry to Canada, you may not apply for a study permit. There are some exceptions to this rule and some options to deal with. So if a visitor is inside Canada and they apply for a study permit online, then the officer will immediately, almost immediately, as soon as they open the application, they will refuse the application because they say you are inside Canada and you are not entitled to apply for a study permit. and because Section 215 does not apply to you. There are some exceptions to this rule. For example, one of the exceptions is that you have done the prerequisite of your studies in Canada and now you're applying. So let's say, for example, somebody is applying for a master's degree in, say, economics. Now, for some reason, I always give this economics example. So somebody is doing a master's degree in economics, and when that person goes to the school to register, the school says that based on your existing credentials, you need to take one course in statistics before you do the actual master's degree. So for one course, if you are a visitor and you're inside Canada, and you want to do just one course in statistics, then you don't need a study permit. Now, as soon as you complete that course and the school agrees to give you an unconditional, basically acceptance letter or letter of acceptance, then in that situation, you may apply for a study permit from inside Canada because you did prerequisite of a program inside Canada. So that's one example. The other example is for some family members of diplomats and children who were minor, and they could study in Canada without a study permit, and now suddenly they need to apply for a study permit because their situation has changed. For example, the family members of a diplomat, because the diplomat is leaving Canada and they want to stay and study, or for children that they were minor, they are not no more minors, so they need to apply for a study permit. In those situations, these people may apply for a study permit from inside Canada. Another example is that you are a visitor, however, you are a family member of a temporary foreign worker or an international student. In that situation, you may apply from inside Canada because of your family member. There are other also exceptions, but these are rare situations. For example, your spouse or common law partner is under an unenforceable removal order. You may apply for a study permit from inside Canada. So if none of those situations apply to you, then unfortunately you cannot apply for a study permit from inside Canada. Before COVID-19, we could submit the application on paper to Visa Application Center in New York, but unfortunately right now Visa Application Center in New York does not process these kinds of applications. I mean, you can send them and they will forward them to the visa office in New York, but the visa office in New York is not processing any on paper applications for now. Will that change? We don't know. I have been, because I have some applications stuck in there. They are not study permit applications, other kinds of applications. And regardless of how many times we follow up with them, nothing is moving forward. So that's the gist of it. So unfortunately, if you cannot apply, if Section 215 does not apply to you, then you need to leave Canada to apply for permanent for study permit. That's the gist of it. But I don't know the specifics of your case. That could be different because of your specific situations. So the next question is by Rommel. Is Ashton accepting reference immigration course for non-Ashton graduates? Refresher immigration. Thanks, Rommel, for being here, first of all. Well, I don't know the answer. You need to get in touch with Ashton College. But my understanding is that for refresher, it's just to help somebody who is graduated from immigration consulting courses, and they still may enter the exam for the AP exam to become immigration consultants. And those people, they could actually get in touch with Ashton College to cover what they have missed. Because in the past, the duration of these programs are 300 hours. Now they are 500 hours. So they covered that 200 hours. So I assume they do register people that are graduates from other schools, but I don't know. You have to get in touch with them directly. So, Ariane, hello, student from Ashton, here again. Loving your live videos as always. Oh, thank you very much, Ariane. It means a lot to me. Whenever I see students or graduates from Ashton College, I feel proud to see you here. Thank you very much for being here. So Matthew says, "Good day, sir. How long does the Canada visa extension takes to approve?" Well, that's a very good question. Nowadays, a very, very, very long time. I mean, I sometimes it could take up to 5, 6 months before they actually decide on the extension request. Um, in I think most recently, I submitted an application for extension. I think in December or January, and just last week we received just a couple of days ago, actually, we received the decision on those extension requests. So it takes a very long time nowadays. But keep that in mind. So let's say your status in Canada expires on, say, June 15th, 2021, okay? And you apply for extension today, okay? So if you apply for extension today, it is extremely unlikely they decide on your application by June 15th. So now June 15th comes and passes. What will happen to you is that you will continue to have implied status because you applied for your application before June 15th. And implied status means that you continue to hold on to your previous status, which in this case could be a visitor visa, until to the point that the officer decides on your new application. If they approve the new application, then whatever date they set on the new application, your status will remain active until that date. But if they refuse the application, that's when you lose your status, and that's when your 90 days for restoration of status begins. So that's the gist of it. Okay. So where I was. Oh, this is Roman. So Roman says how I got application for Canada for 22 years, traveled 7 times to my home country, and times here I got that cessation. I'm permanent resident since 1998. What is the next steps? What should I take? So I didn't quite get your question, Roman, but my understanding is that in the past 23 years, you have been on a permanent resident of Canada, and you are potentially facing a residency obligation issues and you're losing your permanent residence. If that's the case, my recommendation to you is that book an appointment with me or another person who is an expert in the field of immigration, and let's explore if there are any opportunities. As we speak right now, as I'm speaking to you, I'm actually working on a case of residency obligation. I have a hearing on June 22nd, 21st, and I'm preparing my client's disclosure today to submit to the Immigration Refugee Board of Canada. So get in touch with somebody who has dealt with these issues, and they will review your case and they will tell you whether you can revive your permanent residence or not, whether your permanent residence is active or not, and then if you can fight to keep it active, then what are your solutions? Okay. Lucilla says, thank you, sir. You're a professional immigration lawyer. Thank you very much. First of all, I'm not a lawyer. I'm an immigration consultant, but thank you very much. Okay, so Mohammed Diouf just got a job offer in marketing field within my company, and I have been working with this company for 8 years. ICT is activated. What should I do? Can I start remotely while in US? So again, I cannot comment on your specific application because I really don't know what's going on with your application. So I'd rather not to discuss that matter. I don't want to jeopardize your case. because I don't know the details. But if you are going through the ICT program, and for those of you who don't know what ICT is, ICT stands for Intra-Company Transfer. If you have initiated an ICT program, I'm pretty sure that your company has a lawyer who has processed this application or an immigration consultant. Get in touch with that lawyer and immigration consultant, because they know your case, they know the details of your case, and they will tell you what you can or cannot do. Because if you just drop this question to somebody like me, we don't know the details of your case and we could jeopardize your application. But generally speaking, a person may not, this is a very generic question, a person may not enter the Canadian workforce unless they have a work permit. There are some exceptions that people can work in Canada without a work permit. But what will be the answer to your case? Because I don't know the details, I'm not even the right person for you to book a consultation session with me. You need to book a consultation session with the lawyer who processed this application, or the immigration consultant who processed this application. If you go back to me and book a consultation session, then I need to first acquire information from your company and that lawyer to see what happened in the case, then give you advice. So that in this case, it's better to get in touch with them directly. So Rommel says, thank you, sir. Is the validity of the IPP is still 3 years regardless of the change? Thank you. So for now, Rommel, it seems that the answer is yes to your question. It looks like that still, if you have completed your education in less than 3 years, you may continue to enter the EAP or register to the EAP exam. Having said that, keep in mind that sometime in fall, the new college will take over the profession of immigration consultants. And because of that, they may make some changes on their own. So for now, we know that ICCRC is transitioning into the College of Immigration and Citizenship Consultants of Canada. Having said that, when the college takes over and becomes the new regulator, they will definitely have their own sets of rules, and what those sets of rules are, we don't know them yet. Okay, they are working on them. They just recently, government released the Code of Professional Ethics for the new college, and the tentative date or range for the college to take over is this fall. And then what will happen at that time, we don't know yet. Okay. So Roman says, thank you very much. And Mohammed says, thank you again to you. So it looks like that the questions are over. That's great. So just a little bit pitch of what I'm doing. So starting from this Wednesday, I'm teaching a course. It's called Inadmissibility to Canada. It's an advanced program for those people who are already either immigration lawyers or immigration consultants. So if you are interested, you can register to that program. It's an amazing program. Of course, you need to be a licensed practitioner, but it's an amazing program because, not because I'm teaching it, because of the topics that we are going to cover. I pretty much will cover anything from how they evaluate inadmissibility to Canada, what are the reasons for inadmissibility to Canada, and then what would be the consequences of inadmissibility to Canada, and eventually what are the solutions to inadmissibility to Canada. So we'll try to cover inadmissibility from many different angles, and I'm so excited to teach that. If you are interested to attend that course, let me just find the link. So I give the link on my own website because I also explain what I'm teaching over there. This is the link to the program. So if you are interested, you can click on that link and register to the course. Again, as I mentioned, you need to be a practitioner and to be able to register to that course. We're thinking about Ashton College and I, we're thinking about some alternative courses that we could deliver to non-practitioners as well. But for now, we stick with practitioners. So Rupesh says, hello, Rupesh. Good to see you here. Okay, so that's it. Thank you very much for attending this session. As I'm working on my disclosure, I have to stop this session a little bit early, but I will come back next week at the same time on Sunday at 10 o'clock ET or EST, Eastern Standard Time, which is Toronto time. And if you have any questions, just bring them with you and we'll discuss them. Okay, see you soon. Bye.